Shatala chimona umwana wandiko kuyivyalira kasanga tina mulefumo kumwipusha lifumo ly'abandi lifumo ly'abapasitamayo Nongolo lefyo bakupele fumo mayo Mwana evere yaine Ale tumola kupanga kwa munuwe Elo bahulile chipingo Kwambo kulanje baji mwana wesu Alana Yesu alina bakapa wakwe Yesu alikwete Salome Ona Yesu alikwete Maria Magdalena Yesu alikwete Marita Paulo nawe ali na Peti Twise kuli Petero alikwete Doka Kanshukukana ine chimo na Yesu mayo Kawakana ine wakana Paulo Kukana ine chimo na Petro Na yeshio kukana bambadilisha Chebele ni wapazi katata Yesu Kabili mwa pazi kanamwe Ima mwala chitefi tata Kabili mwa shima pepo yangwe Ujete mwa kaya palaji Tumu chote lele ichadwacha Natalo mupamba Shakala chimona Efyo batitiriwa munandika mwatata Papa shitakumu tumo lusaka Alenya ntuka kopyo lukasa na boba tuka Konkonko kuwindo niwerani Ninde pashita changwe niswila ko Maenda shiani bapa sitabu na wishiko Atinalete la kuli sumae Manishi manefe bapa sitaba chindama Chikashana kuipa isula ko Kuingira abamade chikuna Mulume obedi mayo na mpule mwete Mayo na mpele budi koni Omaniweka bika chia leti
Hello, hello, hello. Good evening, Chiwempala. My name is Elias Munshya, and I'm coming to you live on TVBAKWETU. We know that TVBAKWETU comes to you from different time zones, and so whichever time zone you are on, good morning, good afternoon, good evening, good night, wherever you are. I'm doing some, what I'm calling law lectures. And this week we started with just an introduction to law. Okay, today I just want to deal with presumptions at law, okay, or presumptions in law, right? So what are these presumptions? Because they help you understand what the law is all about and how the law works. And so these are not complete, but there are some of them that are going to help you frame your legal understanding. This is not just aimed at people that are already involved in the law, but those that are maybe studying, those that are just curious, and busybodies that have no, just busybodies that just want to know something about the law in a way that that they can understand. So that is the whole point. So on TVBAKWETU, we rely on you becoming a member of our TV by subscribing, by sending stars, or by sharing, by liking, sharing, and encouraging others to join, because that's very important, right? So please do so. And so I am going to share from a presentation, basically. So I'm talking about organizing the law, and that's towards a theory of legal presumptions in the common law. My previous lecture yesterday was aimed at giving you an introduction, right? So we talked about civil law, common law, and particularly in Zambia, much of our law is under what is known as a common law tradition. So is Canada, so is England, so is much of the United States, right? And so the common law is the system of law in our jurisdiction and in our various jurisdictions. But more than that, the common law is also the development of the law itself, how the law has come to us. And so when I say organizing the law towards the legal presumptions in the common law system, I'm talking about these presumptions and how they have come to help us in the common law legal tradition to understand what the law is. Okay, now in the essential characteristic of law and judges and courts is really to come at the truth, right? To find what is the truth. Like when a witness goes to swear before a judge, this is what they do. I promise that I'm going to tell the truth, the whole truth, and nothing but the truth, so help me God. However, the law itself is not an exact science. So you don't go to the law and it's not like mathematics, right? Where 1 + 1 is always equal to. It's not like science where you just apply a scientific formula and you get the same result all the time. It's both a science and an art, and it's a little bit more complex. And so we could say that it is both a science and an art, with particularly the art becoming a little bit more pronounced, right? But the desire to know the truth has engulfed us as humans for perhaps the very time that we were created or born or evolved, whatever you may think about where humans come from. But even when you go to the Bible itself, like you go to the book of Genesis, so Adam and Eve, they transgress against God, right? They sin against God. They do something that God had told them not to do. They listen to the serpent and stuff like that, and then they eat of the fruit. And then God comes and calls them out. Adam, where are you? And Adam hides and says, I'm hidden here. And God asks him, Adam, what's going on? Have you done something wrong, right? And in a little conversation there between Adam and God, Adam finally says, yes, I have sinned against you. The woman that you gave me is the one who gave me a fruit and I ate it. So that's a very important illustration of the desire for people to know the truth, right? Now, in order for us to get the truth, or our court system to go to the truth, or just the law system to get to the truth, we must work under some well-founded presumption. So a presumption is a truth assumed by the law, right? So this is not to say that it is objectively true. It might not even be objectively true, but it's a truth that is assumed by law so that we could organize our legal system in a particular way, in a way that makes sense. Without presumptions, it will be almost impossible for us to get to understand what the law is. It's virtually impossible. So that is what happens. The truth, presumptions, and the law. A presumption is a truth that is assumed by law, right? So legal presumptions are necessary so that the law is at least predictable. You know, in an event where you have to consume or process so much truth, so many facts, it is necessary that at least the law presumes certain things to be true, so that the law is predictable. Without legal presumptions, the common law legal tradition will be much more complex and hazardous than it already is, right? So the law uses presumptions to arrive at truth, for truth is impossible without basic foundations upon which truth could be built. So presumptions are such building blocks. So legal presumptions are like troughs that guide the rivers of justice. Legal presumptions do help organize the law and the society in which it functions. Without legal presumptions, we'll be like beasts unguided, you know. So that's why we need legal presumptions. So there are so many legal presumptions that I can only share with you some. And so we're going to right now delve into some of these legal presumptions. The first presumption is the presumption of innocence. Now, this is mostly found in both constitutional law and criminal law. And the idea is that an accused person is presumed innocent. Again, that's a presumption. It's very important to get this because it is just a presumption. It is not based on fact, right? So for example, and I keep going back to this example all the time, you know. You are sleeping at night and then a thief comes into your house and steals TV and right? And then you hear some noise, you come out and you find this gentleman, Piri or Tembo, you know, Nasen Center, TV, and then he's walking away with it. Obviously, he's stolen it. But even when it is a fact that you found somebody stealing from your house, right? But the law gives a presumption to that person, to that accused person, that they are innocent. That's one of the things. So it's a presumption, and the reason why we need to have this presumption is so that the law can be organized. Because if the beginning point is that every person is guilty, it's going to be quite troublesome. So the law, particularly criminal and constitutional law, wants to presume that every person is innocent. It's a presumption of innocence, right? So that is the beginning point. And so the expectation is that once the person is presumed innocent, the expectation then is that the state is going to build its case to a level where, and beyond a reasonable doubt, they can then convict the person who is presumed innocent. And there are several reasons why that is done. One of the reasons is, first of all, to make sure that the law is organized, to organize the law of a foundation where it's natural. The second thing is so that the state can be able to prove its case, right? Provide the evidence that's needed in order to convict a person for a crime. So that is a presumption, right? And I think it's very popular, the presumption of innocence. All right. The second presumption is the presumption that has got to do with the court. You see, in the common law tradition, including Zambia and Canada and several other countries, we have different levels of courts. Okay? So a presumption about a court's jurisdiction. So court's jurisdiction simply means what the court can do, right? The authority that the court has. So there's this presumption that a court intends to stay within its jurisdiction, right? So for example, in Zambia we have several categories of courts. Right, so we've got courts that are known as common law powers courts. Now, common law powers courts are courts that have inherent jurisdiction, like the High Court. That inherent jurisdiction in the sense that it is a court because it is a court. It has inherent jurisdiction. Those are the courts like the High Court. And then we've got statutory courts. These statutory courts are things like the magistrate courts, the law courts, and various other statutory courts. So what's the statutory court? A court that is created by statute. Small claims court, traffic court, court what and what. All those are statutory courts. And then there are also customary tribunals, customary courts. You know, the courts that are customary law, the courts that chiefs have in their chiefdoms, all those are customary courts. And then there is the statutory tribunals. For example, the tax tribunal in Zambia. Again, all these courts can be different, but the principle remains the same, that they are courts that are given particular jurisdiction by statute. And there is this presumption that when that court is sitting, it intends to stay within its jurisdiction. You know, if it skips and deals with something else, then that decision should be reversed, because there is presumption under the common law that a court intends to stay within its jurisdiction. This at least resolves issues where some courts try to go beyond their jurisdiction. All right. So the first thing was a presumption of innocence. It's a presumption. First presumption. Now, there are several presumptions, and I'm not going to have the time to deal with all of them, but at least the first one is the presumption of innocence. The second one is the presumption that a court intends to stay within its jurisdiction. And then the third one that I'm going to discuss tonight is the presumption of gifts and donations. Now, this is where an issue arises, right? Gifts and donations. So under the law, if you receive a gift, if somebody gives you a gift, right, there is a presumption. Now, again, remember, a presumption is just a way to organize the truth, right? It can be rebuttable, meaning you can lead evidence that rebuts the presumption. But at least at the basic organization of the law, it is presumed that a person who gives you a gift, right, intends to buy something of you. All right. In other words, nobody just gives gifts for the sake of gifts. The law presumes that when that people do not intend to give gifts, but to buy a bargain. If someone gives you 10,000 kwacha and says to you, here is the money for you to buy a car, to buy a house, the law presumes that that money you are given is not a gift, but is given to you in exchange for something, or it's a bargain that the person is trying to buy of you. A person who gives you another person something is presumed to be wanting something from that other person in return. The receiver of the gift must in turn rebut that presumption if it is called into question. Now, again, you must know that whereas there is this presumption, it can always be rebutted, but the rule still remains the same. A person who gives you a gift intends to purchase something. The law presumes that they're trying to purchase something of you, and that is what the law says. That is a presumption that exists. When this is done, it is done because somebody is trying to bargain for something, right? In the Lusaka High Court, there was this issue of the Kapalasa case, right? Now, I don't know how that case has concluded, but at common law, the issue that was being faced there is Mrs. Kapalasa receives a gift from one gentleman known as Joseph Malanji, right? It's a twin cab, Isuzu twin cab car. And then a few months later, Joe Malanji goes for the twin cab and reports it stolen, right? The issue that was going to be decided in a court of law is it right for Malanji to claim the Isuzu, right? So if we follow the presumption at common law, of course, if Malanji gave an Isuzu, just gave an Isuzu, the law presumes that what Malanji is doing is trying to buy something in exchange for that Isuzu. Isuzu or Isuzu, right? That is the presumption. It is up to Mrs. Kapalasa to rebut that presumption by, for example, proving to a court that that gift was given absolutely without condition and Malanji knew what he was doing and he did it because of love or affection for the other friend and donated the Isuzu. Otherwise, without you proving that this was done absolutely in total, as a total gift, as an absolute gift, a court can return the Isuzu back to the person who gave it. All right? So that is one of the things concerning some of us who receive gifts. Now, I'm not saying that, no, go and start refusing our wedding gifts. Of course, receive them, right? Because it's a wedding gift, and it's assumed that if you go to a wedding and then you give somebody a wedding present, it's likely to be a gift, right? And it's likely to be a gift. But beyond that, no. There is a presumption that somebody is trying to purchase something of you. And if you fail to fulfill that promise, they can come back and grab their stuff and grab their money and grab their thing that they gave you, because under the common law, this is a very important presumption, a presumption that people do not intend to give gifts, but rather to buy a bargain or to buy something of another person. All right? So where did we start? We started with the presumption of innocence. We got to a presumption of a court, the fact that a court intends to stay within its jurisdiction. And then we looked at the presumption of gifts and donations. And the next one is the presumption of intention and consequences. So basically, the presumption is that a person intends the consequences of their action, right? So when you do something, the law presumes that you intended the consequences of your actions. Sounds simple, ain't it? So if you punch someone, right? You punch someone and they bleed. The law presumes that you intended, you knew, the consequences of your actions. You intended the consequences of your action. A person is presumed to intend the consequences of their actions. If you act in a certain way, the law presumes that you intended the consequences. Unless you come up with, you rebut that, That presumption may be open to a rebuttal, but at least at the very basic and organizational level, when you are organizing the law, you are presumed to intend the consequences deriving from your own actions. That's very important. If the law were to be opposite, where it says that, no, we can't, you do not intend the consequences of your actions, there'll be chaos in our society. If you punch someone and they get hurt, then your action of punching, you intended to hurt someone by your action of punching, right? Or you take a knife and drive it into somebody's body. You intended the consequences of your actions. That's a very important presumption. You can't say that you're in a won't knife. No, knife. At you in a level won't knife. Wait, mom. You intended to hurt someone with that knife. Okay. Some of these presumptions are a little bit more complex, right? But I am giving you these principles so that you can work with them. All right. So a presumption of intention and consequences. The next one is a presumption of family, children, and parentage. This is very interesting. All right. So, children and family and father, mother, and children. So here, the law presumes that the person who is married to a woman, when a woman has a baby, the law presumes that the man who is married to that woman is the biological father of that child. Right? So the law does not begin asking, are you the father? It doesn't do that. All right? A person born out of a marital relationship is presumed to be fathered by the man. So, akamwana kafyalwa ero kapalaba neba mama kasapalaba mwali teta baneba mwali teta baneba kamwana kamunganda. The law presumes that child's father, that child's biological father, that child's paternal father, paternity, is the person to whom that woman is married. It's a presumption of parentage. The law does not depend on DNAs. In other words, it does not go searching for DNA, no. In a marital relationship, when a child is born, that child belongs to the father. That child is presumed. So if you want to reverse that presumption, you must provide evidence. Maybe that's where a DNA can come in, you prove that it's actually not the case. So what then happens is that a DNA might be there to prove a different fact. But who is going to authorize it? So if a man does not authorize that a DNA be done, and then an innocent bystander goes, compares DNA of this child and the father in the home and comes with evidence from DNA, the court is not going to respect that or consider that because mulomo, right? Because the law already presumes that a child that is born out of a marital relationship, the father is presumed to be the man who is married to that woman. Or if it's after separation, 9 months after separation. You see, that's why I'm a family lawyer, divorce lawyer. And so the date of separation is very important. Just in case, 9 months later, there is a baby. When that baby is born, the law presumes that you are the father. Now, what happens if the child is completely different from you? Like completely, like namwekala na bamada munganda ero mwasa afyala umsungu perera. It doesn't matter, right? Umzungu berera ngafyalwa akamwana nga gafyalwa munganda kamsungu berera ero wetawuli msungu nishi. Still, the law still presumes that you are the biological parent. The other thing is, if you also take some positive steps, or you introduce that child as your child, then that child is your biological child. Even if Tamwampalana, even if Musungu, even if Chinese, Nangshan, it does not matter. I don't know why I've stayed too much on this presumption. So it's a presumption of family, right? And so sometimes it might not be factual, but it is legal. So sometimes fact gives way to what is legal. You could have a factual situation where you are not biologically, by fact, the father, but legally you are the father because of this presumption. Now, you tell me, how do we live in society? Do we live by facts, or we live sometimes by just legal presumptions? like in society, how do we organize our lives, right? Do we just organize our lives by facts, right? Or courts, do they just proceed by facts? This is a fact, therefore it is true, or the law does something different, okay? Yeah, anyway, we'll go to that. The next one is the presumption of death. So this presumption is basically, if a person lives so many years, you don't hear from them for a particular time, they are presumed dead. Again, factually, they may not be dead. Maybe, but more dives. For 14 years, no contact with the family, but maybe they could still be alive. But in a particular jurisdiction, you don't hear from a person for so many years, you can go and apply before court to have them presumed dead. Imagine, Nishnagafwa. Okay, so the common law time used to be 7 years in some cases, but statutes, again, because this program is multi-jurisdictional. So you need to check your country's jurisdiction to find out the presumption of death by statute, right? Because sometimes statutes come in, intervene, and displace the common law rule of 7 years to presume that somebody is dead. So what happens when they come back? Katwish. All right. So that's a presumption of death. The other one is a presumption of birth. So for example, in immigration law in Zambia, Zambian immigration law, Zambian constitutional and immigration law, if a child is found on Zambian soil, right, when they are below 7 years, they don't have any guardian or parent, the law presumes that they were born in Zambia. That's a presumption, right? So even when factually they may not have been born in Zambia, but if they are found in Zambia without any guardian, without any story, they are presumed. That's a presumption of birth. Again, this is where one of the instances where a fact might be displaced by the law, right? Where the law presumes one thing that is contradictory to facts. And where facts and law contradict, it's usually the law that wins all the time. Okay? And what is the law? Sometimes it's common law presumptions. Sometimes it's statute from our parliament. Sometimes it's judicial reasons from a higher court. And this is the argument that, this is the same argument that was with Lungu's third term eligibility. local state term eligibility. The main debate was whether factually his standing in 2021 was a factually third time to stand. That was a fact, all right? But because there was a constitutional court ruling precedent that explained that the other thing that he did would not be counted, the law then came and covered that fact. Now, it's a little bit complicated, and some of you get too excited when we are dealing with political law, that is constitutional and administrative law, right? But these are things that are there all the time, very frequently in law, except that they become much more animated when it comes to political and constitutional law and administrative law. All right. So these are some of the things. So presumptions. So that's the presumptions of birth. The other one is presumption of statutory powers. So so this is very the fact that a statutory body is presumed to stay within its statutory limits. So this is particularly important where a statutory body, very similar to what we said about a court, where a statutory body has the temptation to go outside its jurisdiction. Now, and in subsequent lectures, I'm going to tell you a little bit about the administrative state. But in Zambia, in Canada, and several other common law countries, the administrative state has grown significantly, right? Before the growth of this administrative state, political ministers were responsible for much of the things that were happening, right? They would be the ones that would be setting policy and implementing it. So it was very easy. If you have a problem, it's a minister that has a problem. It's the political party that has a problem. Now, with the proliferation of the administrative state, ministers or government departments started shedding off their responsibility and taking it into statutory bodies. And we have many. In Zambia, for example, in education, we have so many statutory bodies, right? So we have, is it ZACA, the Zambia Qualifications Authority? It's raw qualifications. And then we have the Higher Education Authority. It's raw accrediting institutions. So all these functions a long time ago used to be done by the government directly. But now they're being done by statutory bodies. And so this is the presumption that a statutory body intends to stay within its jurisdiction. This is so that when they step outside jurisdiction, the courts can easily strike down their decisions, right? But statutory bodies also can sometimes conflict. We have a case sometime where the Higher Education Authority and the Zambia Qualifications Authority, they clash. Or, to be specific, a trainer of various institutions, regulators of various institutions clash with the Higher Education Authority. Like recently, there was a clash between who is supposed to accredit health programs in Zambia a few years ago, right? Is it 2 years ago? And so there was a clash between whether HPCZ, Health Professionals Council of Zambia, is the one that is supposed to accredit a particular educational program at a university. And the Higher Education Authority say that they are the ones with that responsibility to accredit that particular program at a university. So there was a clash. Again, how would judges resolve these problems? We go back to this presumption, the idea that statutory bodies intend to stay within their own authority. Okay, so that is in brief the presumptions that are there in our legal systems. I'm going to come back sometime and deal with another topic. If you have any legal topics that you want me to deal with, please let me know, and I'm going to deal with them. So this has been our second presentation on the law. The first one was more like introductory in nature. This one is about legal presumptions. Again, find time to, again, these are not very detailed lectures. They're just like surface things, talking about things that might interest you and make you, first of all, understand the law in a much more better informed position. The other thing is to try and motivate some of you who might want to take up a law degree. Who knows? Just go ahead and do it. And also to motivate, maybe you are already involved in a legal career and you just want to get a few refresher courses. All right? Elias Munshya here on TVBAKWETU. Good night, God bless you, and God bless our country.